We'll talk now about corporate management. First off, let's look at where corporations get their power to exist. As we talked about before, corporations are fictional people. We consider them to be people, but we understand this is a fiction. They are creatures of the state, as we've mentioned before, so they don't exist unless the state says they exist. You can't just create one by agreement the way you can with a partnership. So if you look at the chart on the slide, power originally comes from the state. The state empowers shareholders to buy the shares of stock of the corporation, and these shareholders, in turn, are entitled to elect directors. Directors are those who engage in the long-term planning and management of the business. They're not typically involved in the day-to-day activities of the corporation, but instead more to an oversight role. Directors, in turn, hire officers, and it is the director's job to monitor them and determine their compensation, to determine how effective they are, to give guidance. Officers are just high-level employees, and they typically have pretty fancy-sounding names like CEO, President, Vice President, CFO, COO. The officers, in turn, hire other employees, and depending on the size of the business, of course, that could be a lot or a few. Now again, I want to remind you that officers are all, and other employees, they're all simply employees. So everything that we've learned in employment law applies to them. Everything we've learned in agency law applies to them because they are agents for the corporation. Directors are not agents for the corporation. However, they do owe fiduciary duties to the corporation. Also, recognize that someone can hold more than one of these positions. It's not at all unusual, in fact, it's typical for a director to also be a shareholder, or for an officer also to be a shareholder. But when you run across a problem to solve, ask yourself, in what capacity was that person acting at the time of this event? Were they acting as a shareholder? Were they acting as an officer? That will help put you on the right track to solving the problem. So as I mentioned, directors are not agents, but they do owe fiduciary duties of obedience and loyalty. By obedience, I mean they're following what the corporation is directing them to do, and maybe this is circular, they in turn are directing the corporation on what to do. They have a duty to avoid conflicts of interest. Directors often are in a position of finding out confidential information on strategy of the corporation or exploration of business opportunities. They owe a duty to avoid any conflicts of interest, not to take advantage of that information for any personal purpose. The corporate opportunity doctrine is an important one in business law. What it says is that when officers or directors or other high-level employees, or actually any employee, improperly takes advantage of an opportunity that belonged to a corporation, that's a wrongdoing. What this means is that the corporation had some sort of business prospect, but instead, one of these guys took advantage of it. Corporate opportunity doctrine exists when the opportunity was discovered through someone's corporate capacity, or it may be the type of activity that the corporation often deals in, or that opportunity was developed with corporate resources. It does not exist when the corporation did not have the resources available to take advantage of that opportunity. For example, if they didn't have the money to take advantage of that business opportunity, then the corporate opportunity did not exist, and corporate involvement would be beyond the power of the corporation. It does not exist when a disinterested vote, notice the word disinterest, someone who has no conflict of interest, who has no personal interest. So when a disinterested vote of the board of directors voted against taking advantage of that business opportunity, it has to be someone truly neutral who does not have a conflict of interest. There's another topic we will not be spending much time on because we don't have time to study securities law, but I do want to point out the concept of insider trading. Insider trading is when you trade on inside information, meaning information that is not yet public. When we talked earlier about securities and the origin of the Securities and Exchange Commission, we noted that it arose after the Great Depression, and the idea was to give all investors access to the same information. This doesn't mean that the government is making recommendations on what you should buy or not buy. Rather, it's so that everyone trades on the same information. So if you're successful in the stock market, hopefully this means you simply did better research or you got lucky, but in any event, it wasn't unfair. When you work for a corporation or you're a director of a corporation, you can find out a lot of confidential information. If you find out that the earnings report is bad, for example, your natural inclination is to say, oh my gosh, let me sell. Well, until that information about the earnings report has been released, you're legally forbidden to sell. It's not fair. You have access to information that everyone else doesn't have access to. And I mean everyone trading in the market. So no, you may not trade on that information. The same goes, of course, when the information is good. When you find out that your drug has just been approved by the FDA, but that information is not yet public, no, you cannot go out and buy more shares of stock, predicting that the price of the stock will rise. Insider trading is prohibited as a breach of fiduciary duty, among other things. But also, it's prohibited by federal and state law. There are criminal regulations against it, and there are people in prison right now for violating those rules. How can officers and directors become liable? Well, breach of fiduciary duty. They could be liable if they commit torts, and of course negligence is the most commonly committed tort. It occasionally includes intentional wrongdoing. For example, with fraud. Officers may also be liable if they exceed their authority. We ran up against this when we talked about agency. If an agent says they have authority to enter some agreement when in fact they don't, there are at least two causes of action. One is a contract-based cause of action called breach of warranty of authority. The second would be negligent misrepresentation. The business judgment rule is an important one in studying corporate management. The basic idea is that the judiciary system will not get involved in business decisions unless a business person could not reasonably have made that kind of a decision. If you think about it, judges are judges. They're not business people. They are not going to second guess what a business person decided if that business person was well-intentioned and well-informed. All of us can look at various business decisions over the years the companies have made and said, boy, was that a mistake? It's easy to do that after the fact, but does that mean it was somehow a breach of the officers' or directors' duties to use reasonable care and skill, for example? If they decided to take Coke off the market and instead market new Coke, and I don't know if you guys are old enough to remember that, it was an enormous fiasco initially. And the answer is, of course, the officers and directors are not going to be liable. They thought it sounded like a good idea. They did some research. They genuinely thought it would be an improvement in the business to create a new Coke that tasted sweeter, more like Pepsi. They thought they had already secured the Coke market and would now encroach on its competitor, Pepsi. Well, they were wrong. However, no court is going to go through that and say, oh, they shouldn't have decided that, and they're therefore liable for that mistaken decision. A decision like this clearly falls within the business judgment rule. So, decisions that are based on information and have some sort of rational basis, where there are no conflicts of interest, those kinds of decisions are protected under this rule. And if the Coca-Cola shareholders tried to sue for some sort of breach of duty, they would have been unsuccessful. A developing area of law related to corporate management is what happens with minority shareholders. By minority shareholders, we're typically talking about shareholders in close corporations because the ownership of large corporations is typically so diverse. There are so many different owners, it's actually unusual to have a majority shareholder in the first place. So we're talking about close corporations. Small corporations, not publicly traded, what happens when it's just, say, 3 or 4 people? People who own the shares of stock in a corporation. And by majority, I mean those who own more than 50% of the stock. What happens when they create a block against minority shareholders, i.e. those who don't own that much of the stock? Typically, in corporate management, the majority wins, right? And there are sometimes examples of when they sometimes misuse that majority power. Now we're going to talk a little bit about some laws that imply that the majority may owe a duty to the minority. But let me just caution you that not all states recognize this. This is a developing area of law because it kind of goes against the principle, originally at least, of corporate law, because the shareholders decide what happens. You vote in the same proportion as the number of shares you have in the corporation. And if you don't like what the corporation is doing and you're in the minority, then sell your shares of stock. The problem with close corporations is it's not that easy. It's easy for you to sell your shares in Microsoft if you don't like the way Microsoft is being managed. It's not so easy to sell your shares of the family-run restaurant because you don't like the way your cousins are managing it. Who's going to buy into a minority position in your little restaurant? So there is sort of a reason in many states and a bit in California, the idea that majority shareholders owe a duty to minority shareholders. That is, directors and officers owe a duty to the corporation and to the shareholders as a whole. In other words, the directors and officers owe a duty not to prefer some shareholders over others. The whole idea of corporations is that everyone participates and benefits to the degree of their ownership in the company. No favorites. If the officers or directors engage in an activity to reduce the involvement or the financial rights of minority shareholders, as I pointed out, some jurisdictions do allow them to bring a lawsuit. So here are some examples of times when some courts will intervene. One would be a freeze-out. This is when a corporation decides to merge with another corporation, but they won't allow any of the minority shareholders to participate in that newly merged corporation, and instead will pay them off with cash or some other sort of compensation. A second example would be stock purchase offers with more money being paid per share to those with more shares. So for example, suppose you want to buy that restaurant. Let's say your cousin owns 75% of the restaurant and you own 25%. Well, if someone wants to buy control of that restaurant, are they going to pay you each an equal amount of money per share? Well, actually, they don't really need you. You're only 25%. So if they can gain 75% control over the corporation, they can always outvote you. So they don't have an incentive to offer you very much money for your shares. On the other hand, with your cousin having controlling interest in the business, if they really want the business, they'll pay a premium for that control. In other words, some extra amount of money, because they're not just buying the shares, they're buying control. So while they may be willing to pay you, let's say, $1,000 per share, maybe they'll pay your cousin $5,000 per share. Look carefully, especially in close corporations, for who gets hired as employees, who gets special sweetheart loans for low interest rates, and other sorts of employment-based deals. For example, back to you and your cousin at the restaurant. Does your cousin get to hire all of his kids? Did the kids really show up for work? Or are they really being paid the same amount someone would normally be paid for a restaurant? Or are they getting some sort of sweetheart deal and getting more money? If at the end of the year it turns out there's no profit, in other words, they don't have to pay you any dividends on your stock because they've already been paying out all the cousins' extra salary and bonuses and employment-based benefits. So at the end of the year, there won't be any profit. Do you have a cause of action? Have they really misused their power to your disadvantage? Look at reverse share splits. A share split is normally when the stock is divided. So let's say that you own 100 shares of Apple. If the price gets over a certain amount of money, Apple may declare a stock split so that for each share you now have 2 shares and they're worth half as much money. Let's say that before your shares were worth $200 per share and you had 100 shares. Now there's a stock split and you have 200 shares, but they're only worth half as much money, $100. Are you better off? No. Are you worse off? No. There's no difference. Well, then what's the purpose of it? A stock split is designed to keep all stock trading within the same price range. It's easier to have a market for stock if it trades within something around the same range. Most stock trades are within $20 to $120. It makes it easy for investors to get in and to get out, and that encourages investment. So the stock markets encourage you to declare stock splits to keep your price within the range, or reverse stock splits if you own stocks and now it's gone down in value to, let's say, $10. A reverse stock split would give you half a share for every share you now own, but it would be worth twice as much. Again, there's no net difference in terms of equity on your part, but it puts the selling range back where most stock is being traded. Well, how would this work to oppress minority shareholders? In some corporations, they'll have reverse stock splits that leave the minority with these fractional interests which don't have a market. And in some corporate bylaws, there's a provision that allows the corporation to purchase back any such fractional shares. So this is a way of creating a forced sale by minority shareholders. They don't have any choice. They must sell to the corporation. What remedies might you have? First off, if you are a disgruntled shareholder, it's very difficult to win lawsuits because you don't like the way the corporation is being run. This is a business. Courts don't like to second-guess businesses. And in general, most corporate disputes are governed by the business judgment rule, where this is simply viewed as within the legitimate decision-making scheme of the corporation, and a court will not likely get involved. And as I mentioned before, not all jurisdictions recognize a cause of action for majority oppression of minority shareholders. Some jurisdictions, including California, provide a voluntary dissolution of the corporation. A dissolution is when the corporation ends. Most dissolutions are voluntary. In other words, you and your family simply decide to close down your dry cleaning business. You voluntarily dissolve it and pay off the creditors and collect any amount owed to you and the business. Occasionally, there can be an involuntary dissolution. So it's kind of like a divorce that you don't agree to. This is possible if it looks like there's been a lot of wrongdoing and oppression. In some jurisdictions, a court does have the power to dissolve the corporation in that case. In some cases, a court may appoint provisional directors to come in and take over a corporation to make sure there's no fraud or looting of the corporation. They also, in many jurisdictions, including California, have the power to appoint a receiver. A receiver is someone who's going to receive all the money owed to the corporation and make sure that they're put in the proper accounts, in other words, not stolen. Some corporate bylaws are written to allow arbitration of internal corporate disputes. Again, this would be a way to try to encourage resolution instead of going to litigation. Now, is the management of the corporation liable for torts and crimes? Well, this is going to be a flashback to respondeat superior, so just recall what you learned there. If there's a master-servant relationship and the servant was acting within the scope of employment and during the time when a tort occurred, then the master will be liable. With regard to crime, however, as we discussed earlier, there's really no vicarious liability because most crime requires a particular state of mind, and you can't simply transfer your mental state to someone else. The exception is with crimes that do not require any particular intent. These sometimes fall under regulatory law, for example, securities violations, mail fraud, environmental pollution. But with everyday traditional criminal activity, there's no such thing as vicarious liability for it. If you drive the getaway car while your cousin robs a bank, did you rob a bank? You might be liable for some different crime, for example, aiding and abetting a bank robbery, but you yourself did not rob the bank. The same idea comes with corporate and management liability for torts and crimes. What about indemnification? Can the corporation reimburse its employees, officers, directors if they get sued for malfeasance? The general answer is yes, and the corporation can also purchase insurance for this risk. The corporation can indemnify or get insurance to indemnify malfeasance if it was at most negligent but not intentional. You cannot be reimbursed for intentionally causing harm to someone else. It's a violation of public policy to indemnify people if they intentionally or recklessly cause harm to others. But for mere negligence, yes, the corporation may, but is not required, to indemnify its officers, directors, and employees. I once served as a director at a bank, a credit union. It was a nonprofit, and I agreed to do so only if the bylaws were amended to indemnify me in the event that I was sued, and that the credit union purchased a policy of insurance to pay for that indemnification. Was I planning to commit negligence? Of course not, but you don't always control when someone is going to be happy with the activities of the organization and they sue everybody, and I wasn't going to take that risk just for serving as a director on the credit union. Okay, this concludes our discussion.